Yeah, we are seeing the wealthiest generation in Australia's history get to that stage of life where they're starting to look to transition and transfer those assets to their children. And as we see there, we're expecting $3.5 trillion to be passed in the next 15 years. All of that, a lot of that is going to be passed by their wills, and what we're finding is only 50% of Australians have a will. And for those that do have a will, of that 50%, only 12.5% of those wills are estimated to be accurate. And that means that people may have made a will previously, but either it was done poorly or done at home and done wrong altogether, or what was appropriate then has not been reviewed as time's gone on, the law's changed, or their situation has changed, and the will they have is no longer appropriate for them.
I think that's an astounding number, Matthew. Looking at that $3.5 trillion figure gives us some idea that there's around about $2 trillion worth of wealth that doesn't have a valid or accurate will covering it.
Yeah,
it's remarkable.
It absolutely is, and speaks to why estate litigation is going to continue growing.
Indeed.
So when we're talking about your estate plan, we do tend to separate your personal estate plan from your business succession plan. So if we're looking at your personal estate plan, we're looking at all the things that you control. So the things that you own, the things you control, and you as well come into play when dealing with your personal estate plan. And what we're talking about is, right now, you're making all of these decisions for yourself. What happens if you can't make those decisions for yourself any longer? Who's going to make those decisions for you? And after you pass away, who's going to take control and who's going to benefit? So your legal and financial decision maker, as you stand right now, you're deciding what bank to use. You're deciding where to live, what property to buy or sell. You're deciding what insurer. And all of these decisions you make on a daily basis, you probably don't even think twice about it. But if you were to lose capacity, if you lost the ability to make those decisions for yourself, who's going to step in and make those decisions for you? Who's going to administer or manage your legal and financial decision making for you? Similarly, right now, you decide which doctor to visit. You decide what treatments to undertake, what dentist, what physiotherapist. If you weren't able to make those decisions for yourself, if you weren't able to judge which is the preferred doctor or which medication should I be taking, possibly where should I be living? Is it still safe to live at home? If you're not in a position to make those decisions, who is going to make them for you? Who's going to step in, and who would you like to be stepping in to make those decisions for you? So they're the two areas of during life estate planning we focus on. We then have the after death estate planning as well. So that includes what happens when you die, who's going to take control, who's going to benefit from your estate. It also includes your superannuation, your life insurance. These are for a large proportion of Australians right now, superannuation and life insurance make up the majority of what their wealth would be in death. And they do not necessarily pass in accordance with the will, that they do require specific focus on succession planning and estate planning for those two types of asset. Similarly, you may have interests in a company, and that company may own a whole heap of assets. How are your interests in those companies going to be protected if you were to lose capacity or pass away? How are the decisions that you would have made for that company, how would they be made on your behalf? And same with trusts. You may be a trustee, you may be an appointer or a beneficiary of a trust. How will your interest in those trusts be protected if you were to lose the ability to make decisions for yourself?
That's a very good overview, Matthew. I very much like the way you've set that out, that I think those first 2 points are the ones that are often overlooked. We often hear people say, well, yeah, I'll get a will for when I die.
Yep.
And an estate plan, but I think it's so important, those points, that 2 top points there, that as to what happens if I lose capacity, I get beyond being able to make those decisions for myself.
And it probably speaks to the wonderful optimism of humanity, that no one actually thinks it's going to be them that goes through this situation. But the fact is, unexpected things arise, and that is a very real eventuality for a lot of people.
That's good.
So here you can see the different types of assets you may own siloed to make it very clear that they are different assets and treated differently. So your estate assets, these are assets that are held in your name. These are things that you own in your name, in your personal capacity. Can be bank accounts, could be shares, it could be property, your cars, your personal effects, all of those sorts of things. They're what's called your estate assets. Your directed assets, these are in totality your superannuation and your life insurance. They're called your directed assets because they pass differently to your estate assets. They pass in accordance with the directions that you have given to the super fund or the insurer. Joint assets are assets you hold as joint tenants with another person. So there's where you hold assets, where you own assets with another person or other people, there's two ways that you can own it. Tenants in common, where you each own a share of the asset, or joint tenants. Joint tenants has the characteristic where the surviving owner or tenant takes control of the entire asset after the death of the first. So it doesn't matter what you have in your will. If you have own assets as joint tenants with another person, the surviving tenant will take ownership of the whole. And this is particularly important in Australia, where the vast majority of married couples who own their family home do so as joint tenants. That also, oftentimes, the bank accounts in the relationship are held jointly too. And so these are not considered estate assets. We then have trust assets. Trust assets are assets that are owned by a trust. It is not uncommon for families to set up trusts to own their most valuable assets from a tax maximization perspective or minimization perspective, or risk minimization perspective. However, it's important to note, even though you may control those assets as if you own them, assets that are owned by trust are not considered estate assets, and they also will not pass in accordance with your will. And finally, it's becoming far more common for Australians to own assets overseas. That might be because you have lived overseas for a period. It might be because you have migrated or your parents have migrated and they've retained property overseas. It may be that just investment opportunities have arisen overseas, and so that's why you own assets overseas. It's important to note, foreign assets are not considered estate assets under New South Wales law as well.
That's a very interesting presentation of it, Matthew. I think it's quite amazing to see how little of the assets that we hold are actually part of the estate and therefore covered by our will. And I think it's us accountants that are probably the culprits for recommending that assets are held by trusts, and generally for very good reason.
Absolutely.
Properties, business, real property, businesses might all be held by trusts and by companies, and there's good reason for that. But to understand it, therefore, that piece of paper I call my will,
yeah,
they fall outside the scope of that.
They do indeed. Here we see all those various types of assets that we spoke about on the last slide. And we've now identified how each of those types of assets is going to pass to your beneficiaries. So like we spoke about with your estate assets, they will pass in accordance with your will. Assuming you have one, they will pass in accordance with the will. If you don't have one, then the laws of intestacy apply. That's not the scope of today's conversation. Where you have a will in place, you will be nominating your beneficiaries. It might be, there are different types of wills, but it's important to know that that's how your estate assets will pass to your beneficiaries. Your directed assets, like we said, this is your superannuation and your life insurance. So they're going to pass in accordance with the binding death benefit nomination you have submitted to your super fund, or if you have life insurance sitting outside your super fund, you will nominate the beneficiary on the policy of the fund. It's important to note with your binding death benefit nominations, there are only certain categories of people who can inherit your super tax-free. There are also only certain categories of person that you can nominate on your binding death benefit nomination. If you are looking to nominate other people, you need to nominate your legal personal representative so that your superannuation will pass into your will. Your trust assets, like we spoke about, these are not estate assets. You do not own any assets that are owned by the trust. Instead, the trust will continue operating after you pass away, but the succession provisions of the trust deed itself will determine who takes control of that trust and ultimately who can benefit from the trust. Your joint assets, like I spoke about, they have the characteristic of survivorship. So the surviving joint tenant will automatically take control of the entire property. You may own your home as joint tenants with someone else, and you may include in your will, I give my share of this property to Joe Bloggs. Unfortunately, that clause is not going to have any effect whatsoever because your interest in that property will have already ceased at the time of death. And finally, like I spoke about, foreign assets, they will pass in accordance with the law of the jurisdiction that holds those assets. So if you have shares in the US, then those shares will pass in accordance with the law in that jurisdiction.
Very good summary again, Matthew. And once again, just articulates the point, doesn't it, that I may say, well, I'm leaving everything in my family, but whether we've thought through that there's these 5 different areas that assets need to pass through to get the totality of my assets to them.
Yeah. Okay, so when we're talking about your estate assets, like we said, they pass in accordance with your will. Now, how are we going to set up the will? There are a couple of different ways we can do that. And the first is what we call the simple will. Now, that is very much a misnomer. Estate succession legislation and case law is absolutely guaranteed there's nothing simple about a simple will. However, it's called a simple will because your beneficiaries simply inherit the assets that you give them. That means that in that will, you will nominate an executor to take control of those assets for the period of administration. And then once the executor is ready, they're going to distribute the assets to the beneficiaries. So any assets that you've given to a beneficiary will just be thrown into the pool of assets they already own. In effect, they'll become estate assets of your beneficiaries. The alternative way to set up a will is what we call a will incorporating a testamentary trust or a TT will. Now, TT will, rather than giving your estate to your beneficiaries, your will is going to create a trust. So a lot of you may have a family trust set up already to own assets. A TT, a testamentary trust, is slightly different. The terms of the trust are written into your will itself, so nothing will come into existence during your lifetime. But upon your death, rather than giving your estate assets to your beneficiaries, the trust will be set up and your estate assets will be passed to the trust itself to be controlled by the people that you nominate. Now, why would you set up a testamentary trust? It sounds like a lot more administration, a lot more effort. I'm going to invite Gavin here to start speaking about the tax benefits.
Yeah, thanks, Matthew. There's certainly some tax benefits to be had. And so we thought we'd just put this out as a bit of a case study. And so what we're looking at there is a family, John and Melanie, for the sake of this example. And unfortunately, Melanie has passed away, leaving John and 3 children who will ultimately receive the assets that Melanie held. Now, Melanie's assets consisted of around about $2 million. She had a life insurance policy, and that could be any other asset for that matter. And she had some shares, $2 million, all told that she had. Now, John is a businessman and let's say has personal income of $250,000 per year. He's quite successful, running quite a good show. Now, without a testamentary trust, that $2 million will go straight to him because in the earlier example, a simple will would normally be husband leaves to wife or vice versa. And so John receives these assets straight into his own name and invests those proceeds. Now, being already in the top tax bracket, for the sake of this example, we've said that he has income of $250,000. That means he's paying a marginal tax rate of 47%, which is certainly getting onto into the top bracket of income tax. So he invests this and manages to get a 6% return on investment, which means that without a testamentary trust, investment's $2 million, he gets $120,000 each year. The tax he pays on that is $56,400 because it just gets lumped straight on top of his current salary and wage income. So after tax of the $120,000 he's got, he's left with only $64,600 due to the fact that it was a simple will that those assets passed to him under. If, however, he had a testamentary trust, the assets fall down into that testamentary trust where he again invests them and achieves the same level of return on investment of 6%, which again is the $120,000 per year. With a testamentary trust, he can then distribute that income down to his children. Now, I think many of us on the call would know that when it comes to a normal family trust or discretionary trust, that we can't distribute any more than $416 per year to a minor child without it triggering penalty tax. In a testamentary trust, every child is regarded as an adult for tax purposes. And so you can see in this case, the $120,000 has gone to 3 children who each have access to the lower tax thresholds, meaning that they pay $4,500 each in tax, which means that they pay a total amount of tax combined of $13,600, which leaves $106,000 remaining of the $120,000 from their mother's inheritance. Now, when we put those numbers against each other, in 1 year alone, we've got a tax saving there of over $40,000 simply for having a will with a testamentary trust built into it, instead of that being a simple will whereby John would have received Melanie's assets directly.
Yeah, and when you put the numbers up there, it immediately becomes a bit of a no-brainer that the benefits, while it might be administratively a bit more of a hassle to make the will, and it might cost a little bit more in the short term, a year-on-year return like that, that's substantial.
Indeed.
Now they're the tax benefits to a testamentary trust. I'm a lawyer, so I'm more focused on risk and how do we protect our assets. And so where you have your beneficiaries inheriting your estate by way of simple will, like I said before, the assets that you're giving to them, those estate assets, are just going to be thrown into their existing pool of assets, which means that from the moment that your estate is distributed, those assets belong to your beneficiaries as if they were their own forever. With a testamentary trust, however, because there's that distance between your beneficiary and ownership of the assets, the trust itself is the entity that owns the assets. It means that if your beneficiary were to go through a family law dispute, for example, or be sued for whatever reason and possibly end up going through bankruptcy proceedings, if your beneficiary went through any of these situations, because of that distance between them and the assets themselves, the assets won't be called in to either of those two matters. It means that they could go through the family law dispute, separate, come to an agreement on the settlement of their family assets, and then come out the other side and have your full use of what you have given them at the other end of that. Similarly with the bankruptcy, if the creditors have taken everything else that your beneficiary owns, at least when they come out the other end of that bankruptcy, they're going to have use of these wonderful assets you've given to them by way of testamentary trust. And so we're going to,
That's excellent summary. And I think throughout the generations, many of our clients are running businesses. No, this could have a place even if somebody faced something like a director negligence claim even.
Absolutely.
And certainly a much safer place to have the assets tucked away.
Yeah. So we're going to look at business succession planning now. We've just dealt with the personal estate plan. We're now looking at business succession. When we're looking at business succession, oftentimes businesses are owned by companies or by trusts. Where you have a trust, oftentimes you'll have a company acting as the trustee. So with regard to companies, the question is always who controls the company and who owns the company, especially where you have a sole director, shareholder, or perhaps one or two directors and shareholders. The question of who controls it and who owns it can become very much it's the same people. But as companies grow, there very much can be differences. So the first thing when you're going through this situation, you need to think about is, do I control the company or do I own it? Am I a shareholder or am I a director? So it's the shareholders who own the company and it's the directors who control it. In the end, so the directors are making the day-to-day business decisions, and it's the shareholders overall who determine who the directors are going to be. So you need to make sure in a business succession capacity, if you are a director, making sure that there are appropriate succession mechanisms for continuing, so for people to continue in that role of director. And if you own a company, making sure that if you lost capacity or if you were to pass away, that appropriate people are being elected to those directorship roles. And it's the appropriate people who you nominate to exercise your rights as a shareholder. Default mechanisms. The default mechanisms are your estate plan if you don't have an estate plan. So every entity is going to have default mechanisms in place. What happens if there's a vacancy in any number of roles? So default mechanisms for a company, if you pass away, then the shares that you own, if you are a shareholder, the shares that you own will pass in accordance with your will. Okay, so you may be in business and you have certain ideas about people that you would like to take over control and ownership of that business. You need to make sure those provisions are built into your will. Succession or default mechanisms of control. If you are a director, if you're a sole director of a company, then and you're that sole member, then who is going to be able to take control? Who's going to make those directorial decisions? Now, your personal power of attorney that you've set up in your personal estate plan, they're able to exercise your rights as a shareholder of a company, but they're not able to exercise your rights as a director of a company. So it will be up to your personal, if default mechanisms here, your personal power of attorney will be electing someone else to act as, or your executor, sorry, will be electing someone to act as a director. Now that may not be the person you want acting as a director, but it will be your attorney's decision until succession of the shares is finalized. And so with regard to directors' decision making, you may be one of 4 directors and you may be one of 4 owners of the company. If you're not able to exercise your decision-making capacity as a director, all of a sudden you don't have a say in the business decisions of that company. So you need to make sure that you have, and this comes as part of the company succession plan, maybe each director is able to nominate a substitute director or a reserve director to act in the event that they can't, so that each shareholder's interests are still being protected at decision-making level. Similarly with trusts, there is a distinction between control and ownership. The trust itself is an entity that owns all of the assets of the trust. However, nobody actually owns the trust. Control of the trust is held by the trustee. The trustee is the person or the entity that goes and makes all the financial decisions, all the investment decisions, all the distribution decisions, who's going to benefit from the trust. And it's the appointor who decides who the trustee is going to be. So overall power in that trust is held by the appointor to nominate who the trustee is going to be. The danger of default mechanisms here, the trust deed will set out who will take on these roles in any vacancy. Oftentimes it is the legal personal representative of the last remaining trustee or appointor. And that means that either their power of attorney, if they're still alive and no longer able to make decisions, or their executor if they have passed away. And so very quickly, and we're going to show you a case study shortly that will highlight for you how quickly control of the trust can move away from the people that you would really want to be controlling that trust.
Very good point to highlight, Matthew, because so often these provisions are buried in documents that the trust deed we signed 20 years ago when we started in business, and the constitution that went with it. Yeah. And it's kind of gathering dust in the bottom drawer, but yet the importance of these provisions can't be overestimated, can it?
No, absolutely. And sometimes best case scenario is that constitutional trustee is gathering dust in the bottom of a drawer, because there are definitely occasions where over the passage of time, people move home and all of these sorts of things, and those crucial documents can get lost, which brings whole new challenges to the whole plan. So we have here our second case study. So we have mum and dad. They've built a business together. They're doing really well. They own the business in a family trust that they've set up, and they're both the trustees in their personal capacity of that family trust. But as the trust owns the business, profits from the business get funneled into that trust and then distributed through themselves and through their 3 children. They have 3 children: Julie, Tom, and Mark. Julie is married to Bob. They have 2 children. Tom is not married and is unlikely to be married. And Mark is married to Lynn, and they have 3 children. Julie and Tom both work in the business and work in the day-to-day of the business. And it's likely that they will take on management roles as mum and dad start phasing themselves out. Mark, although he may have once worked in the business, has chosen not to continue. He has employment elsewhere. But mum and dad, recognizing that the business is the major asset in their estate, would like Julie, Tom, and Mark to benefit equally from the profits, whilst Julie and Tom receive recognition for the fact that they are actively growing the business themselves. So mum and dad recently have prepared their personal estate plans. So they've made wills, they've made appointments of enduring guardian, and crucially, they've made enduring powers of attorney, in which they appoint one another, and then they appoint Julie as their backup attorney. They appointed Julie because, being the eldest, she's always been the more sensible of the children, and Tom and Mark, being completely upfront, didn't want the responsibility. They didn't want the added headache of acting in that role. So they were on board as well. Unfortunately, Dad has passed away, and Mum has just lost capacity. So she, whilst is alive, is no longer able to make decisions for the business. Dad, obviously, having passed away, can't either. This means that with regard to the family trust, which owns the business and controls the business, now Julie, as the attorney for Mum, under the default mechanisms, Julie is now the sole trustee of that family trust, which means that she has total control over the business decisions. She also has total control over distribution of profits between the rest of the family members. Now, I know what you're thinking, but this isn't a problem, because Julie is sensible. She realizes it's family first, and she's working with Mark and Tom, and she's making sure everything is fair and working for the family. Unfortunately, Julie has now passed away as well. This family's had a horrible year. But what that means, Julie has also set up her personal estate plan, and Bob is Julie's executor, as most married couples are going to set up in their personal estate plans. Now, Bob, he seems a great guy. He seems a great dad to the kids, but he's no Julie. He's also not a member of the direct family. He's not the person Mum and Dad would have, if given the choice 12 months ago, would have nominated to be controller of the family trust and therefore the business itself. We run the risk here with Bob in control. He may decide to not make distributions to other members of the family. He may also go and repartner. And so all of a sudden, Bob and his new partner still have control of that family business. This is just a way to illustrate that under default mechanisms, the control of your entity or your estate can quickly move away from who you would have wanted to take control.
It's a very enlightening, Matthew. And I'm sure there's many on the call today that could have these very provisions sitting in place. And as you say, Bob might be a great guy now, but dollar signs do funny things to people.
Amazing things, and we see it in estate administration all the time. Yeah, there's very few clients who come to us and don't say that their kids get along really well and all the in-laws are good people. ahead of time. Estate administration, you see the other side of people, unfortunately.
No doubt.
So when we're talking about your estate plan, what documents are we actually recommending you put in place? So with regard to your personal estate plan, number one, the simple one, the will. Okay, whether it's appropriate to have a simple will or a will incorporating a testamentary trust, that's something for your solicitor to advise you on. But regardless, everyone, if you are over the age of 18, if you have a bank account or a super fund, so a super account, any assets whatsoever, you need a will. You need a will. It's not a something for retirement. Every single person who's over 18 that owns an asset needs a will in place now, and it does need to be reviewed fairly regularly. Now, the will is a very black and white set of terms and conditions that I appoint this person, they have these powers, and these people receive my inheritance. The letter of wishes is this wonderful document that sits beside the will. It's a non-legal document that allows you to communicate with your executors how you would like your estate to be administered. You can include essential information such as what your passwords are for your digital assets, who your advisors are. So you could put Quantum's details in there as your attorneys and as your accountants, and so that your executor knows that when they're trying to administer the estate, go straight to Gavin to get a full list of assets and entities. You can include details if you have minor children. Who are the doctors? Where would you like them to be schooled? What philosophies would you like them to be raised with? All of these crucial information that doesn't get included in a will. You also need an enduring power of attorney. So this is the legal and financial decision maker that we spoke about earlier. This will empower someone to pay your bills, to buy and sell property. If you need to go into assisted living, oftentimes that will necessitate the selling of the family home. Who's going to do that? Even if you own it as joint tenants, you do require both parties to sign the document of the transfer. Appointment of enduring guardian. This is your medical and lifestyle decision maker. Who's going to be giving instructions to the doctor or to the dentist or to whoever it might be? What medical treatments are you going to undergo? And finally, your superannuation nominations. Now, this is crucial because there are only certain categories of person who can inherit super trust tax-free. And so you need to be careful about who it is you're nominating to receive your superannuation. And like I said, most super nominations, binding death benefit nominations, lapse after 3 years. So this is something that you need to be reviewing on an ongoing basis.
Good point you raised to the tax on super. It can be very hefty, can be anything up to 17% of a super balance, and it's not uncommon to see super balances of up to several $1 million.
Absolutely.
Which, if that's directed to the wrong dependent, can be very expensive.
Definitely. And the list of people in your life that can receive your super tax-free is going to change throughout the duration of your life as well. So this is why we say these things need to be reviewed on an ongoing basis. As children get older, they will all of a sudden not be considered these tax benefit dependents as well. And then your business succession plans, the documents that can be used to implement your business succession plan. Very simply, corporate powers of attorney. So that if you are a director of a company, if you're the only director or if there are multiple directors, a corporate power of attorney authorizes another person or people to make decisions for the company. So if you are not in a position to be able to make those decisions, now this doesn't have to be a worst case scenario. It might be husband and wife team are the two directors of the company, and they've gone for a couple of weeks or a month in Europe. Then all of a sudden you're out of the jurisdiction. Making decisions is a lot more difficult. Executing documents is a lot more difficult. A corporate power of attorney will allow you to put Julie, for example, in place so that she can continue to just sign documents on behalf of the company. A shareholder agreement is an agreement between the shareholders, strangely enough, that sets out the rules of the relationship between those shareholders. So it will include dispute resolution provisions. So if the shareholders don't come to an agreement on certain decisions or electing directors, that sort of thing, this shareholders agreement will set out the procedure for coming to a solution so that the company is not stuck in deadlock, and all parties can move forward. This is especially important where you have family businesses, where not only are you in business together, you're a family. There are deeper relationships to preserve and to consider in all of this. The succession provisions of the company, that can be included in both the trust deeds and the company constitution. So succession provisions, making it clear, for example, in a company constitution, that you can be very specific about the type of people who can act as a director or who can act as shareholders. So you can limit shareholdings to direct lineal descendants of yourself, or you can limit directors to direct lineal descendants or an independent director, and set out that the independent director must have acted as a director for 5 years elsewhere, or so on. So you can make it very clear that the decision making for these entities is able to continue, and then once you pass away, the appropriate people take control and take ownership.
That's very good. I think it gives a very, very clear picture of the documentation required. Shareholder agreement is certainly a very important one, and company constitution likewise.
Absolutely, can be very valuable as well. There's some really cool things that some families have put in place in the constitution, setting out that line of succession, just all as a way of making sure control is continued, and it minimises the chances of dispute in amongst the family as well.
That's excellent. So no doubt, Matthew, I'm sure you've triggered a lot of questions in the minds of those on the call, and certainly would have provoked a lot of thought. Certainly happy to take questions if anyone wants to just type them into the box. Just having a look. Yeah. Any questions popped up here? Okay, so I've got one question. I'm in business, haven't given estate planning or a will any thought. Where do I start?
Well, I would say,
yeah,
I would say start with Gavin. Go and speak to your accountant and get a full list of what you own and how you own it, so that, like we spoke about with those early slides, so that you get an idea of possibly an early start of what documents you may think are necessary.
I think putting that into those silos, I think, is very, very important as a starting point, just to see what assets you have sitting where, what's joint, what's going to be dictated to by the will, what's in trust, what's company, what's foreign, and so on. And even down to the detail of who's filling what roles. I mean, the difference between whether just dad's the director or whether both dad and mum are directors can have a massive impact on how the estate planning piece of that happens, can't it?
Absolutely, yeah. And your second move is go and get legal advice. Go and speak to your solicitor. Make sure that they're well versed in your personal estate planning matters, but also that business succession piece. And they will tell you very clearly, and with the help of the silos that Gavin's gone and prepared, that what documents are necessary. You don't need to come to these meetings with all of the answers. The purpose of seeking counsel from your advisors is so that we can bring that expertise to the table.
That's good. Another question as to if I don't have an enduring power of attorney or enduring guardian, and I cease to be able to make decisions for myself, what happens?
Yeah, very good question. So there are state-based mechanisms involved. So you're not going to be left laying on the ground with no one able to make those decisions for you. What your loved ones will need to do is go and make an application for a guardianship order with the Civil and Administrative Tribunal. So in New South Wales, it's NCAT, and you'll need to go your loved ones will need to go and convince the tribunal that you have lost the ability to make these decisions for yourself. And then once they're convinced of that, you'll need to convince them that you're the right person to make those decisions for them. Now, this isn't necessarily a simple process, and it's at a time when your loved one has lost capacity, clearly something has gone quite wrong, it can be a very burdensome process. So for the sake of the people who will be trying to help you out and manage your affairs and take care of you, it's definitely a lot simpler in the long run to just go and put these documents in place.
Absolutely. It doesn't sound like a very convenient way of going about it.
It's not, no.
Very good. Could we run through the difference between a shareholders agreement and a company constitution again?
Yeah, absolutely. So there's a lot of grounds that both documents are going to cover, but the shareholders agreement, the constitution sets out the rules of the company itself. So it sets out how shares are going to be issued. It sets out how directors are to be elected. It sets out what powers the shareholders have versus the directors, and so on.
Could you say one's legal, the other's operational?
Well, I mean,
they're both legal.
They're both legal, yeah, absolutely.
Shareholder agreement will get into a lot of detail on the day-to-day running of the company.
It does. So the shareholder agreement very much determines the interactions of the shareholders between themselves and how shareholders are going to be able to execute those powers. It can include provisions for the protection of minority shareholders, so that you may only hold 5% of the shares, and so in theory your interest is quite small and you wouldn't necessarily have much of a say in the company. You can include provisions in the shareholders agreement that would give a bit more power to those minority shareholders.
That's good. How do intangible assets get treated in succession planning?
How do intangible assets?
Correct.
So are we talking sort of shares?
Yes.
Publicly listed shares?
It's not clear from this. I'd probably take it would be probably a family business that has built up a significant base of IP.
Mm-hmm.
It would really just be dealt with the general provisions of the succession of the business, wouldn't it?
That's right. Yeah. So the IP, for example, that is the property of the business itself. So that might be owned by a trust. It may be owned by a company, which is, if it's owned by a company and the shareholders of the company are individuals, then the individuals through their company will own that IP, but it is the company that owns it. If the business is owned by way of trust, then it's the trust that owns it, and so the trustee makes the decisions and executes ownership rights over the IP.
Very good. Is there a template for drafting a company constitution? I think what we're saying is that templates don't always work, do they?
No, they do not. Especially with the constitution, there's a lot of nuance in the drafting of it. A lot of the provisions relate to other provisions in there. So changes to a template in one section will necessitate changes in others, and there's a lot of background statutory law and case-based law that will impact that constitution that needs to be considered in any changes or the creation of any constitution.
That's good, Matthew. There doesn't appear to be any further questions, so we might wrap it up there. I think we're now running over time. So certainly appreciate everyone coming on board today, and certainly a warm thanks on behalf of Quantum, and thanks to Matthew for your insights and expertise. It's been very interesting.
Thank you for having me. It's been a lot of fun.
No problem at all. And there will be a short pop-up survey as you leave today's webinar, which just asks some feedback, which we're always glad of. And again, thanks for joining us, and we look forward to seeing you again in the webinar soon, and have a good afternoon.